delighted. I'm part of the health ministry team, as is Betty, and I don't see all of our teammates here yet. But many pieces go into health ministry and so on, and you all know that I deal with older adults and so on, and how their lifestyles are changing, and what that can do to some of their preparedness features that maybe were put into place, and now we have health issues and things of that nature. So I see changes coming through the lives of my own tenants and so on, and I'm just such a big believer in being proactive. So we wanted to have Dunlap and Seeger back. Tina Moore has represented Dunlap and Seeger a number of times, talking about, basically, are your legal affairs in order? With the economic changes that we've seen recently, changes so many times in family structure and so on, it never hurts to just give some contemplative thought to what, if your current plan is saying what you want it to for your legacy and so on. So Tina wasn't available, but she recommended this lovely young woman, and I never made the connection that this young woman, Melissa Saunders, is Connie and Bob's daughter-in-law. How about that? So she's one of our own. So I will let her enlighten us, and thank you again for doing this. Thank you for having me.
Okay, I think this is working, so you can probably all hear me in the back of the room. I feel so far away. At any time, feel free to ask a question. So I find it much more enjoyable when we have a lot of interaction and questions. So don't be shy. Also, if there's something else you want to ask me afterwards, then that's fine too. So today we're going to talk a little bit about an overview of estate planning and the different things that you need to consider when trying to figure out whether or not all of your affairs are in order. Because there's a lot of different dimensions to it other than I have my will. Because a lot of people just think estate planning, I have my will in place, and that's kind of the narrow focus. But we want to try to broaden that a little bit and talk about all the things that go along with the estate plan as well as the estate plan. So first thing I want to talk about is the various options that we see for estate planning. A lot of people we see doing beneficiary designations for their accounts, whether that's joint accounts, POD, pay on death, transfer on death accounts, and beneficiary designations for your life insurance policies, your 401ks. And I'll get into a little bit later how we want to see those in conjunction with your estate plan, and for some reasons why we don't always think that those work the best, depending on the situation. We also now have what's called a transfer on death deed, which is for real estate. So now we can actually do those kind of transfers not only with their cash accounts, but also with real property. So we're seeing some people do that. Probably the most common one that people are familiar with is the will, which is a document that lays out what you want to happen to your assets after you pass away. And that is something that has to go through the probate system in order to be effective, which a lot of people don't necessarily realize. A lot of people come into our office saying, well, I don't have a probate, I have my will. And that's where we have to educate and say, no, a will actually has to be probated to be effective. So that's a big misconception. The one thing that we see that avoids probate is going to be a trust. Typically for estate planning purposes would be a revocable trust, where you put your assets into this trust and you lay out how it's going to be managed, not only at the time of your death, but also upon disability. So if at some point in time you're not able to manage your assets, you have somebody and instructions for that person laid out within the trust. There's also irrevocable trust that you might have heard of. There's several different reasons to do irrevocable trust. Some of them hold insurance, some of them hold homesteads, some of them can be for children who have disabilities where you're protecting some assets for their benefit. But those are mainly done for estate tax type planning or things of that nature, so they're not as common as the revocable trust. So that's just kind of an overview of the things I'm going to talk about. We'll get into detail about all of those items. One of the first questions that a lot of people ask is, why can't I just go out and get the form on the internet? A lot of times all these forms are available now on the internet with kits and things like that. I like to give people some caution in doing that. I've seen quite a few of these documents, and a lot of them, even though they say that this is a Minnesota power of attorney or a Minnesota will, the language in there is that I've seen, and the ones I've seen, has been pretty broad and generic in an attempt to cover numerous states. And so a lot of the terminology isn't going to match up to what we normally see in our estate plans. Another thing I've noticed lately too, because I recently had somebody actually emailing their documents to me that did it on the internet, and I took a look at them for her. And while I think the document would have been effective, even though there were some questions about some of the terminology, there were a lot of things that she hadn't given thought to when she was putting in some of the provisions that she filled out. So I kind of pointed out a few of those things. Is that really how you want your kids to get them? Is that really when you want your kids to get the money? Are you sure you just want to name your parents as your personal representatives because you don't have a backup and they're older than you? I mean, there's just some things that hadn't gone into it that she would have gotten had she sat down with somebody and really thought through those items. So. When we do an estate plan, the very first thing that we do when somebody calls is we send them out a questionnaire. And a big part of this questionnaire is first to get biographical data on people. If you're filling out a questionnaire for an attorney, let me tell you, the best way to save time on this estate plan is to make sure you're detailed about your kids' names and where they live, because that saves you a lot of time in the meeting spelling out their names and getting their addresses. So it's really helpful to have that in writing ahead of time. The other big thing that we do on those questionnaires is a financial asset inventory for you. Because what your assets are, how they're held, who they're beneficiary to, have a huge effect on how we do your estate plan and what type of estate plan we would recommend for you. So it's really good. I have people who you can tell don't want to give out that information, that every 10 minutes that the conference goes on, there's another CD or piece of real estate that I find out about. So it's really important to be honest and upfront. They're not asking because they're just curious about what your assets are. It really is important to the type of estate plan and the drafting of your estate plan to really have a full financial picture of what it is that you own. Because we really do want to make sure that we have the whole picture. Otherwise, we might inadvertently not do what's best really in your situation. So assets that we're really looking for, well, all assets really, but the common ones are going to be real estate. Obviously, your homestead, and we also want to know, what your equity is and what is owed on it, because that affects how we plan and how we look at what your assets and how we arrange it. Also important to talk about if you have real estate in other states, because a lot of times we have people with condos in Arizona and Florida or lake homes in Wisconsin, and if you have property in other states, that's very important to your estate plan, because you might be looking at 2 different probates in 2 different states. And while our probate system tends to be fairly straightforward and smooth and not really expensive, other states are not that way. They are much more burdensome and much more expensive. Wisconsin charges a flat fee, filing fee based on the amount of assets in your state. So I've recently learned that this can be a very hefty amount, fairly quickly. Like 2% of your estate in Wisconsin just to file a probate if you have to do that. So that can get pretty expensive. So that's when we're looking at revocable trust as an option. We'll get into that a little bit more. Cash accounts then, obviously savings accounts, checking accounts, money markets, and again, if you have PODs and joint accounts on that, that is something that we really, really want to know about. A lot of times, and I think now is probably a good time to talk about this, a lot of times people put on their accounts, one child is joint for convenience purposes. We usually recommend that you do that with a power of attorney instead of a joint account. There's a lot of times we have then when mom or dad passes away, the one who was taking care of the checking account has been doing a lot of work for mom and dad. Well, they intended for that account to be mine, and I'm not going to share it with my brother and sister. We see this all too often, unfortunately, and while it sounded like, they agreed when they opened the account, yeah, absolutely, I'm going to share it with my siblings. I don't have any question that we're going to share this account, not a problem. But they don't realize at the time really what kind of a commitment they're necessarily signing on to when they say they're going to take care of mom and dad. Because that does tend to be pretty overwhelming and a lot more work than people realize, or it can be. So we have a lot of change of heart when it comes to that sort of thing. Similar situation with a POD or a TOD. We've had it before plenty of times where they put one child on the account and they're going to share it with their siblings. That can run into a few troubles too. Again, the not wanting to share it with your siblings for one reason or another. And second of all, there's gift tax consequences when that child shares that POD or transfer on death account. There can be consequences for their estate planning that need to be considered. They might not just be able to write out a $20,000 check to their sibling because the estate tax exemption is $13,000. So you've actually created some difficulty for them inadvertently. So that's something that not a lot of people necessarily consider at the time. Also, there can be, if one child predeceases you and you haven't changed that, there can be some challenges. It might accidentally wipe out that deceased child's children, which isn't your intent. It was to have the grandkids share that share, which is what most people tend to do in their estate plan. That might accidentally be overridden, depending on how you had that beneficiary designation. Having said that, we have a lot of people who effectively use that with small estates, small families. They do effectively use the POD, TOD designations. But you want people to be able to share as well. If you have one account and the kids have to pay the funeral home bill, maybe one's going to pay and the other's not. So there's other ramifications for that. Same with the transfer on death deed for the house. One thing that I always remind people, and we do this frequently for people, where really their only probate asset is going to be a house, and they want it to go to their 2 children or their 3 children. We remind them that on death, that is automatically going to transfer to your children, and they're going to be owners of that piece of property. So they have to agree with their siblings to sell the house, what to sell it for, and we're going to need spouses to sign off on that as well. Because of the Minnesota real estate rules, we ask that the spouses sign off on that. So I've had people who, they got 6 kids and they're like, oh, that's just too many people to come to one consensus. We'd rather do a probate than have to see them get into an argument. Let's just designate our one PR to take care of it, a personal representative to take care of that asset. So there's a lot of things to consider while a lot of people come in saying, I have to avoid probate, I have to avoid probate. It isn't always the best option to avoid probate. The advantage of that probate is to have one person or 2 people, who you name, in charge so that they can be the ones making the decision. They're, of course, going to be ultimately responsible to everybody else, but you don't have that fighting and disagreement, which we all would like to think doesn't happen, but unfortunately it does. Stocks and bonds are similar to the cash account with the beneficiary designation. Annuities and life insurance, we usually see direct beneficiaries on those. So the life insurance company, the annuity company will contact directly the heirs in order to have that distributed. So that usually works fairly smoothly. I do recommend, of course, if there's an estate that we're going to be probating and there is not a lot of cash in it, to maybe look at if one of the life insurance policies should go to the estate to pay some of those bills. So that's just something that I consider with people when we're looking at their overall estate and how much cash is in the estate and what they're trying to